Your Honor, my name is McDonald. I'm the elected prosecutor in Oakland County. And before I get started, I want to state that I've dedicated my entire adult life to helping and advocating for kids. I was a public school teacher, a prosecutor, a family law attorney, a family law judge, and I ran for this job on a platform of fair and just prosecution. Treat kids like kids, show compassion, try to help people avoid the criminal justice system. When I took office, I reversed the prior prosecutor's decision on juvenile life without parole sentences, 26 out of 30 individuals who were serving life without parole sentences for crimes they committed when they were juveniles. Based on those decisions, many were released. I did that because I believe in the sound reasoning and policy of Miller versus Alabama, which is a United States Supreme Court decision from 2012. I believe that a juvenile's youth and their characteristics should be weighed, considered before imposing the most harshest of sentence, except the death penalty. I believe it is a rare person who can be labeled irreparably corrupt, especially when that individual is a juvenile. I believe that the practice and pattern before Miller was that the criminal justice system made no distinction between a juvenile and an adult, and that needed to change. Before Miller, if a juvenile was charged for what is considered adult behavior, they were treated as an adult. I tell you all this because I believe it's my duty and my moral obligation to be transparent about why I stand here today, because it's the last place I thought I would ever be. Standing here with a room full of parents and family members that had their children murdered, shot, and terrorized. Asking this court, or any court, to sentence a 17-year-old to life without parole for a crime he committed when he was 15, it was the last place I thought I would be. And it is the last place I want to be. In her opening, defense counsel stated, a court, quote, must undertake a searching inquiry into the particular juvenile as well as the particular offense and determine whether this is truly the rare juvenile for whom life without parole is constitutionally proportionate, end quote. Historically, Your Honor, advocates and jurists, prosecutors, defense attorneys on each side have framed their position around a juvenile life without parole sentence by leaving out essential components. Those who oppose a life without parole sentence for juveniles focus only on the mitigating circumstances of the offender and only mention that, of course, the crimes were heinous. Likewise, proponents describe only the horrific acts of a crime, but for the most part, ignore the individual mitigating circumstances and the offender. You're not going to hear me do that, Your Honor. I'm the prosecutor. I'm taking this position. But I'm not going to ignore any of the facts, whether they help the defendant or help my position or they don't. And I haven't allowed any member of my team to do that since the day of that shooting. I have instructed, and they have done, to look at all the facts and the data and the research and the science and, most importantly, the truth, and consider all of it. And after having done that, I'm standing here today and I'm asking you to sentence him to a life without parole sentence. United States Supreme Court Justice Sotomayor, who authored the Miller opinion in 2012, stated during the oral argument on that case, quote, not every juvenile is equal, not every murder is equal, end quote. So let's review what the testimony showed us about this particular juvenile and these particular murders. Ultimately, Your Honor, your task is to answer this question. Does the evidence surrounding this defendant and these offenses, when viewed in the face of any mitigating evidence that the Miller factors may offer, justify a life without parole sentence? And I believe, Your Honor, you will conclude that it does. I know the court is well aware of the law. We're dealing here with Miller versus Alabama, a United States Supreme Court decision from 2012, then Jones v. Mississippi from 2021, and then a Michigan Supreme Court case, People versus Taylor, in 2022. And what do those cases together ask us to do? What does it require the court to do? It requires the judge to fashion a proportionate sentence. And fashioning that sentence, the court can consider and should consider the core reasons and what makes a proportional sentence historically in this country, dating back to the 8th Amendment and the Constitution of the United States. And those are the following: deterrence, punishment, retribution, rehabilitation, and then protection of the public. In doing so, the court is required to consider the offense, the offender, the Miller factors, and anything else the court decides is relevant. It should be rare. It should be rare, Your Honor. And that's why we as prosecutors have a duty to use our discretion and follow the law, and that's what we've done here today. The first Miller factor asks the court to consider the juvenile and this crime in relation to the hallmark features of a juvenile or an adolescent brain, which involve immaturity, impetuosity, and failure to appreciate the risks and consequences. Your Honor, I argue that the evidence shows that his actions reflect the opposite of these hallmark features. There was extensive planning, and the court heard that. We heard that he put toilet paper in his ears to protect his hearing before the shooting. He researched and knew what kind of weapon he needed, and the one his parents already had for him was not going to do the job. So he advocated for a higher power firearm with more deadly bullets. He practiced. He went to the shooting range and he practiced. And if you have any question about that, look at the shooter's stance during that shooting, during that video of those awful minutes where he murdered 4 kids. He wrote about his plan over and over and over again. He searched up a map of the school on his phone. He searched that there would be no and new death penalty in Michigan. He knew which prisons a juvenile could be sent to. He knew that he would be sentenced to a life without parole. He knew the average response time of law enforcement that it takes to get to a school once a school shooting is reported. Your Honor, he also sat during those Alice trainings. He was also in those classrooms where they taught people like Heidi how to install a night lock device. He knew the damage the particular bullet of this weapon would cause on a human body. He bought, and with his mother, when he was there at the shooting range, he bought and saved rounds from that day for this shooting. And even their expert, Dr. King, stated on cross-examination, he did not believe this was an impulsive act. The implementing, their expert, Dr. Daniel Keating, who I have a lot of respect for, and what he's contributed to this analysis and mitigation experts, describes this phenomenon of a runaway train, where adolescents and teenagers can get into a situation and they're not equipped to stop it, and they don't know what to do. That's not what happened here. There was an execution of this plan. There were opportunities to stop. There was the picking and choosing of who would die. There was a level of comfort with the ease with the violence and pain causing to young baby birds, to young children, and a level of excitement and joy. He learned firearm discipline. He surrendered before he ever even saw the police because he wanted to live. Over and over, he stated, and the defense experts stated, he wanted a chance to be caught. Well, Your Honor, he sat in the counselor's office from 9:14 a.m. to 10:52 a.m. and never once said, I have a gun and I'm going to go shoot up the school, because no one else knew he had access to a gun other than the shooter, except his 2 parents. But in that room, he did not say that. He fired 32 shots, and every single shot was aiming at a human being. This was not a spray of gunfire in the hallway. It was intentionally aiming at human beings. The second Miller factor asked this court appropriately to weigh his family and home environment, for which he cannot usually extricate himself. Your Honor, The people agree that James and Jennifer Crumbly neglected their son. The people agree that the text, that messages he sent when he was 10 and they couldn't be bothered to come home are heartbreaking. We agree that he was isolated, that when his only friend left, his mother made it worse by saying he would never be his friend again. We agree that they did not make him a priority. We agree that it has been shocking and devastating to have your parents say to the school counselor, we don't have time to take him for help. I agree with all of that, and I have compassion. I do. But both things can be true. We can feel compassion, but we can also fashion an appropriate sentence and reckon with the very severe, rare circumstances of this crime. We tragically have hundreds of kids every year who suffer severe physical abuse, sexual abuse, neglect. We have kids who can't count on meals or food when they get home from school, and some that don't even have a home. Except we have a very, very small number of adolescents who commit mass shootings. And this factor does not predominate over any of the other evidence surrounding this offense. The Miller Factor 3 is the circumstances of the homicide and the juvenile's role, and whether there were other actors, whether he was in situations in the past where there's been an aider and abettor, or the person who drove the getaway car. Not this situation, he was the only actor. Miller Factor 4 asks the court to consider the incompetencies of youth, which affect the ability to maybe be charged with a lesser crime. There's no mitigation evidence as to that factor. And then lastly, the possibility of rehabilitation. I told you at the outset, nobody has a crystal ball. And we really haven't heard much about whether or not the defendant and the shooter can be rehabilitated in such a definitive way, because it would probably be improper and unethical to say that. And I do want to point out that this process of this Miller hearing, as a prosecutor, given the case law, is imperfect. The people do not have an option of having an expert evaluate the shooter in the Miller case. We don't have the benefit or the right to demand an evaluation so that we can go hire an expert that we believe is credible to opine on whether there are mitigating factors and what that means. In fact, we asked for that for the defense, if we could have somebody interview and evaluate him for the purposes of whether to ask for a life without parole sentence, and they refused, which is their right, but they refused. I agree that juveniles have an increased capacity to change and grow, which indicates their actions are from transient immaturity. Here, though, there's a severe propensity and desire to commit violent and disturbing acts. And we see that by the fact that even after he was jailed in the Oakland County Jail, he used a tablet improperly and wrongfully accessed the settings on that tablet that he was provided, and visited a reality gore website. I don't want to say the name because I don't want to give that website any more distinction. And when asked as to why he did that, he said he couldn't stop it. Taylor, the Michigan Supreme Court, does not require us as prosecutors to prove, or the court to conclude that the defendant is irreparably corrupt. Instead, taken together by the United States Supreme Court decisions and Taylor, the court has to consider many things. The first is the offender. What does the evidence show? A propensity for violence, a fascination with weapons, a self-admitted desire to, quote, do bad. He consumed mass amounts of violent content online leading up to the school shooting, which include videos of people being shot, attacked with a machete, and stabbed, of a cat being boiled alive, a child being crushed by a van. He tortured and killed baby birds and recorded himself doing so, and then relished in how disturbing his acts were. Your Honor, I'm aware that the courts viewed that video, and I respect the fact that you did not want it to be shown here. But we needed to describe it. And if you did see the video, which I know that you did, I did as well. And the most disturbing part about it, shockingly, isn't the mutilation and torture of these tiny, tiny little living things, and drills going through their stomach, and burning wings. The most disturbing part about it was the defendant's voice as he was doing it. He was playful. He exhibited pleasure from it. And it's something I will never forget. He discussed his desire to stalk, kidnap, rape, torture, and kill people on numerous occasions. For example, kidnapping, raping, torturing, killing, and dissecting another student. In a separate instance, he discussed drowning small children and how it would be, quote, the best feeling to look them in their eyes as they look back at you while they know that their entire life is about to end so young. And to, quote, stick your fingers into their eye sockets and push down so they scream in pain and drown their lungs with water, end quote. Defendant followed up by stating, whenever I see a little kid about a year old or a little more, I want to pick them up and run off with them, then torture them before throwing them off a cliff. He took pleasure in his appetite for violence, even acknowledging it was wrong by making comments such as, I love the darkness, it feels good, knowing that you're different from society and not some mindless human like all the others. We have the ability to do stuff and that other people think is wrong, and we can tell ourselves that it's okay. He wrote, but I want to do bad, it satisfies me. He wrote, killing the innocent is the same as killing the bad. It both satisfies. And he wrote, scary thing is I like being this fucked up. I like it. I like being like this, end quote. Does a propensity for extreme violence and disturbing thoughts, actions mean he's necessarily mentally ill? As hard as it is for us to accept, we know from the testimony of a medically certified psychiatrist that it isn't. I have to talk about the offense now, and I know you've sat through a lot of really difficult testimony. The defendant shot 4 kids and wounded 7. At 12:51, he came out of the bathroom and shot Phoebe Arthur, who was a freshman and 14 years old. He shot her in the neck and the collarbone. He then shot Elijah Mueller in the face. He was 14 years old at the time. He was also a freshman. At 12:51 and 14, he shot Riley Franz, who was shot in the neck area. Riley was 17 years old at the time, and she was a senior. Kylie Osage was shot next in the chest and the shoulder area. Kylie was 17 and a senior. He then shot Hannah St. Juliana, and we know that he killed her. She was shot multiple times in the left upper back, the abdomen, the thigh, and the forearm. She was 14 years old at that time, Your Honor. She was a freshman. And the thing that really I do not believe we can forget is that after shooting her, he turned back and shot her again. Because it wasn't enough that she was already on the ground bleeding. At 12:51 and 16, he shot John Asciutto in the lower extremities. He was 17 years old at the time and a senior. We teach kids to run, hide, fight. And I will never forget the time I had to show Madison Baldwin's mother the video of how she actually died. Because Madison didn't run. Her instinct was to crouch down and curl up in a ball and put her hands over her head. He shot her at point blank range. She was 17 and she was a senior. At 12:52, Tate Meir walks into the building and is shot in the back of the head. Tate was 16 at the time and he was a junior. At 12:52, Aiden Watson was shot in the lower left leg in front of his shin, and he was a sophomore. Seconds later, he turned back and he shot Tate for a second time in the lower extremity. At 12:52 and 54, he looked Molly Darnell, who was a teacher at Oxford High School, in the eyes, and he shot through the window and missed her heart by centimeters. After that, at 12:58, in the bathroom, he motioned for Justin Schilling to come out of the stall, put him down on the ground, and shot him in the back of the head. He was 17 years old. He was a senior. In his last moments, he helped another student, Keegan Gregory, who testified. You heard Keegan's testimony. You heard what it was like in that bathroom. You also heard him say that he said, please, as he was crouched on the toilet, as Justin instructed him to do. And he ran. He ran as fast as he could, and it's the only reason he's alive. These students, they didn't attack the defendant, Your Honor. They didn't go after him. They didn't even try to really protect themselves. They surrendered. They did what he told them to do, and then he executed Justin Schilling. And he only stopped because there was no one left to shoot. You saw the video. Those kids were trained to go into lockdown, and they did. At the time the defendant went into the bathroom where he found Justin and Keegan, there were no more students to shoot, and there were no more classrooms left to be unlocked. Your Honor, I asked Keegan, and I showed him, which was very difficult for him, the text messages that he sent to his family when he was in that stall. But I can't urge enough how we must not forget that the defendant is also charged and has been convicted of terrorism. Because there were hundreds of kids in that building who wrote and texted their parents very similar things. And parents everywhere who received those text messages from their kids saying, there's a shooter, I'm scared, I love you. Because they weren't sure they would ever see their parents again. These kids were young, Your Honor. They were the innocents that the defendant wanted to kill. They didn't fight back. They didn't pose a threat. They were helpless, like the birds. And not only did this happen in a manner in which the motivation behind the acts, which is the very distinct thing I would like to leave with this court. These acts were carried out in cold and a calculated manner, no question. They were intended to have a devastating effect on as many people as he could, but they were also intended to derive pleasure and satisfaction from violence and nothing else. He stated he wanted to kill young people because they had their whole life ahead of them and they had a future. And he succeeded. He said, every night I lie awake, every passing minute I think about how many potential people will die. Think about it, all 10. People are living their lives right now thinking about how they will get a job and party at college and have a family and live a long life. However, what they don't know is that they only have a few months to live before they enter the dark void. Yes, exclamation point. He said the first victim has to be a pretty girl with a future so she can suffer just like me. He said he liked specifically killing the young birds because the birds,
Good afternoon, and thank you for joining us here on CBS News Detroit at noon. I'm Terrence Friday.
And I'm Meredith Bruckner. Closing arguments, as you see, are underway now as part of the Oxford High School shooter's Miller hearing. We want to warn you that what you hear might be disturbing.
Ammunition. As I stated, he knew that Michigan didn't have a death penalty, and he had the map of the school. This was an extended period of planning that was reflected in the journal. Passage after passage in the journal discusses his plan to shoot up the school, including his goal, because the biggest school shooting have the biggest school shooting of this decade. His intent to kill the victims, to make the victims' families with sadness and distraught, and how he wanted all of America to see the darkness in him and hate him. He weighed the pros and cons of how he would conclude this horrific acts and debated whether he would kill himself or surrender to law enforcement. Defense counsel brought up Jill Peterson, who is the author of The Violence Project. And we consulted with, and she testified. in another proceeding. And I found that interesting because the one thing Jill Peterson will tell you, that in her extensive, comprehensive, thorough database of mass shooters in this country, not one of them made a plan to stay alive so that he could see the suffering of the victims' families. He expressly contemplated these consequences through his journal and acknowledged that he would be spending the rest of his life in prison, and wrote the following: "I'm about to shoot up the school and spend the rest of my life in prison. So yeah, I'm going to prison for life, and many people have about 1 day to live. I'm probably going to live the rest of my life in prison. I hope I can talk to someone, though, so I don't take my anger out on other prisoners. Ever since I was little, I've wondered what it would be like in prison. Prison sounds harsh and no place to live, but it fits me and how I want to live. I'm going to spend the rest of my life in prison, rotting away like a tomato. I wonder what life in prison will be like. I will continue shooting people until police breach the building. I will then surrender to them and plead guilty to life in prison." We'll never know if he heard the police or not. I don't know that. I'm not going to pretend that I do. What I do know is that they had breached the building, but they hadn't gotten to the defendant yet, and he surrendered. In one of the recordings, he states, "I understand my consequences. I understand that people put me in prison for this. I've already said goodbye to everything. I went through all the phases." He acknowledged and he understood the wrongfulness of these actions and the consequences, which is at the core of why we needed in this country Miller versus Alabama, because we recognize the unique adolescent mind and its failure to really adequately understand the consequences. I don't know of a single other case where a juvenile has actually written extensively about the consequences of his future actions. He demonstrated this through a last message he sent to his friend: "I'm about to do something really bad and there's no turning back, so I will probably never be able to see you again." The exchange with Christie, the assistant principal, is both jarring but remarkable from an evidentiary standpoint and for the decision that you have to make. Because the defendant had already shot and killed students at that time, and he made a decision not to shoot her. And when you look at the defendant's demeanor throughout this whole proceeding, there was one time he was emotional, and it was when she was testifying. Because it was pretty clear this woman's dedicated her whole life to kids. She cared about the defendant. She'd known him for some time. She knew him when he was in elementary school. And she spoke about him with tenderness. But he didn't shoot her. And she didn't back down because she wanted to save tape. He then went on to execute Justin Schilling after that and shoot Molly Darnell. Your Honor, the defense counsel also stated in her opening that she would offer not excuses, but explanations. I'm not even going to tell you the number of juvenile life without parole hearings and opinions and arguments I've listened to. But those cases, in almost all of them, there was nothing like this, because there was an explanation. We might not like it, but there was an explanation. There was a theft. There was a robbery. There was a violent eruption between family members. There was a plot among peers, adolescent peers, and one thing led to another, and they all did this together, and there was pressure. There was substance abuse. There might be a drug deal. There was gang violence. There's a context, and it did offer an explanation. No excuses. Where is the explanation? I did not hear it. I did not hear it, but I did hear how their expert believes he's mentally ill. And I want to talk about that, because the central question of whether the defendant is mentally ill is applicable to the Miller factors. There's no doubt. But it is not the central question in this case, because this is not an insanity defense. And in fact, the insanity defense was withdrawn in this case, which means there is no acknowledgement or even argument that he meets the statutory requirement for insanity. Yet, we sat and listened to Dr. King talk about all of the reasons why he thought he was mentally ill. And we like to think that there's got to be a terrible mental illness associated with somebody who derives pleasure from dark, violent things. I want to believe that. I do. But you know what else I believe in more? Science, data, research, doctors. And you cannot refute that. And that is what Dr.
All right, we are hearing from Oakland County Prosecutor Karen McDonald on this fourth day of the Miller hearing for the Oxford school shooter. We do have to take a quick break, but our coverage continues on the stream.
We'll be right back.
Have a word for what Dr. King described, mental health issues in this country. He did them all. He did every single person and every kid in the United States who's ever had suicide ideations a disservice because he referred to them as psychotic. And beyond his testimony not being credible about the defendant, that is unconscionable. But the issue of mental illness you should consider. And if you decide that there's some mental health issues, I'm not going to persuade you not to. But it's to be considered in the light of the Miller factors. This is not an insanity defense hearing. That was withdrawn. And I think this is an attempt to divert. And if it's an attempt to get compassion, he has it. He's got my compassion. I can do both things. You can do both things. We all have to do both things. We have to deal with the darkness and the violence, and we have to accept that it happened. And we can also say, we wish he had had a better upbringing. But we're not going to ignore facts. And the facts are that he had a choice, he had many opportunities, he plotted, he planned, he shows none of the mitigating factors and evidence that you see in hundreds of other juvenile life without parole cases. And I'm going to ask the court once again to rely on the testimony and the truth. The issue of what the school should have done or what somebody else should have done is not relevant, and it's not a mitigating factor. And blaming somebody else for not stopping a school shooter is for a different proceeding. But it is absolutely not inconsistent with saying that he made choices evaluating him, the offender, and the offense. He is guilty, he pled guilty, and he should serve the rest of his life in prison. Your Honor, this process is imperfect. We don't have the ability to get our own expert. We bear the burden, but we only have to rely on what the defense submits as their experts. And there are a lot of problems with one of those experts. That expert, Dr. King, came to this courtroom. He didn't know how many minutes the shooting took place. Didn't know how Justin Schilling died. And when I told you before when I started, I'm not going to ignore the facts that don't support my position. We all have a duty to look at it all and to take the stand and only evaluate and report facts and circumstances that support an opinion, and ignore what happened in the school is not the law, and it's also not the right thing to do. A proportional sentence also includes what's right and proportional with regard to retribution, and that means we cannot evolve in a way that we will only apply our sense of decency without hearing what the victims went through. That is at the core constitutionally of what we should consider when we sentence anyone. And so we are obligated to tell their story and to tell what it was like, because that is constitutionally why and how the court fashions a proportional sentence. Your Honor, it's morally complicated to doom someone to life at the age of 17. I know it. I'm not going to stand here and say that it's not. But I told you at the beginning that I was going to rely and demanded that this team rely and consider all the facts and all of the factors that the case law says we should, and all of the mitigating factors and all of it. Put it on the table. And while it's morally and legally complicated to do so, after having done that, I stand here today and I ask you to sentence the shooter to life without parole. Thank you.